Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. It's time again for our friend TJ to ask us some questions about Canadian politics. TJ?
Thanks, Dale. So, my curiosity is piqued this week by what happens to the Supreme Court, or what can happen to the Supreme Court as an outcome of an election in Canada. In the US, it's very politically charged. Even the whole idea of if there's going to be an impending retirement or anything like this really directs political campaigns and even how people vote in terms of who will be appointing that justice. I do remember that I asked you about the balance on the court, and you mentioned it as a gender balance, whereas just so far ahead of where the US is, where I was just asking about political leanings balance. So I just love to get some more context on that.
All right. Oftentimes there is kind of a bit of a paranoia around what might happen to Supreme Court appointments after an election. Usually it's progressives who are worried that conservatives will appoint conservative judges. The thing is that it's never really proven to be an issue in Canada. Partially because our legal community in Canada is not very polarized ideologically speaking. We don't have the same kind of arch conservatives in the legal community that make it to the judiciary that are more prevalent in the United States. So, as an example, there was a lot of people worried that all of these appointments that Stephen Harper made to the Supreme Court were going to turn out to be ideological and do whatever he, wanted. By the end of Harper's time in government, he'd appointed 6 of the 9 judges, and they still kept turning him down and striking down a bunch of the laws that his government passed. So, that fear has never really come to pass. And I think that brings a very different dynamic to the Supreme Court in Canada than we would find in the United States. We also don't have a polarized nomination system. Because the U.S. needs their appointments to be confirmed by the U.S. Senate, that does create another partisan or polarized dynamic in how that works. In Canada, it is simply an appointment of the Prime Minister, but it's usually on the recommendation of like bar associations and law societies and so on, that he can, that his office will consult when an appointment is made. This is something that the previous Harper government started to try and do a much more parliamentary involved process by getting MPs to vet a shortlist. That kind of blew up in his face after one of his appointments was deemed unsuitable by the Supreme Court, actually, having to do with the fact that it was for one of the reserved Quebec seats on the Supreme Court, and the person that Harper chose was not deemed to be eligible for that. And after that, Harper just kind of did away with that process for involving MPs. What Justin Trudeau's done is created an expert roundtable headed by former Prime Minister Kim Campbell, and they do kind of the vetting of the short list and bring that to the Prime Minister.
So, 2 things. That's very interesting, the idea that Harper appointed 6 of the 9. And also, what is this thing about seats allocated for Quebec? So there's a seat allocation on the Canadian Supreme Court?
Partially. Of the 9 seats, 3 are reserved for Quebec because Quebec has a separate legal system. Quebec follows the civil code, whereas the rest of Canada uses common law.
Wow.
So in order to ensure that Quebec and the civil code has adequate representation, there are 3 constitutionally guaranteed seats for Quebec on the Supreme Court. The other seats have a more or less regional dynamic that's arrived more by convention than by the Constitution. So it tends to be on top of the 3 from Quebec, you've got 3 from Ontario being the largest province, 2 from the West, and 1 from Atlantic Canada.
Okay, and then basically, the only way that you get openings on the court here are retirements or somebody dying. So if there's something open, how's it work here?
There is a mandatory retirement age of 75.
Oh,
And oftentimes judges will retire early. It's not very often that they will sit to the full 75 for whatever reason. I mean, it is a very demanding court, and these judges tend to work very long days for most of the year, and if they're from another part of the country, I mean, they need to be based in Ottawa for the time that the court sits, which is about 9 or 10 months of the year, so it can be very difficult on those family issues as well. So we don't always see justices sitting to all the way to 75. We just had a retirement, an early retirement from one of the Quebec judges, and a new one was sworn in just last week. So it's one of those things where we get a lot more churn and turnover on our bench than the Americans do.
so is the court able to continue to function when somebody retires or vacates a seat, or has to wait until somebody new is sworn in?
When someone retires, they have 6 months to basically finish all the decisions that they have currently that they're working on, and they're allocated still their clerks in the space and everything like that. So they've got 6 months to basically finish up what's on their desk.
Okay, so it's not going to be a case like we see in the U.S. where certain justices are saying that if an outcome happens in the American election, they will grimly hold on for another term no matter what, so that they aren't replaced by the president they don't want to be choosing.
Yeah, because we've got a mandatory retirement age, that doesn't really hold here.
Well, the last kind of thing that this is leading me to, actually, is given the amount of churn, as you say, that occurs, it seems like as in any human societal structure, we have alliances that form. Some of them are more formalized into block voting almost, like you do tend to see in certain momentum issues in the Supreme Court of the U.S. But do you see these alliances and shifting dynamics happening even by voting pattern, or just by who's dissenting to what, who's going on the record to what in the Supreme Court here?
There are a couple of different dynamics. The previous Chief Justice was very much about consensus building. So we had a lot of unanimous decisions when she was the Chief Justice, but it also meant that the decisions tended to be very, very narrow. So they would answer a very narrow question and get unanimous consent or unanimous ruling on it, and didn't really broaden the scope on many of their decisions. The current Chief Justice, we haven't seen nearly as many unanimous decisions, and we've also had a couple of more recent appointments to the bench which are far more likely to dissent than previous benches would. So we're seeing a lot more split decisions now than we did under the McLaughlin era, but that's not necessarily a bad thing. Unanimous decisions are good for certain cases when the court needs to make a particular point, but in cases where it's a point of law that there is disagreement on, it's healthy to have dissent like that, because you get that academic airing of those issues in a judgment.
Well, my takeaway from this, as from many of our conversations about governmental structures in the US versus Canada, is that there seems to be a lot of nuance one has to consider when both analyzing the past behaviors of Canadian systems, particularly the Supreme Court it seems, and also trying to predict what will happen in the future with them. So it'll be interesting for me to watch as this new group kind of settles into its rhythm, and to keep an eye on what's coming across their desk. So thank you.
You're very welcome. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at Journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.